आवाज येतोय का? रोहित सर.
Yes, Ansh, am I audible? Yes, Ansh, am I audible?
Yes, sir, you are. Am I
Oh,
audible?
yes, beta. Yeah.
Sure.
Oh. Welcome, Vikrant sir. Dr. Vikrant, welcome, sir. Students will start the session in 5 to 10 minutes.
So am I audible?
Yes, sir, you are audible, sir.
We will start in 5 minutes. Okay, sir.
Yes, sir. Vikrant sir, are we audible?
Yes, sir. Yes.
Okay, sir. We'll just start. Yeah,
Yes, sir.
in 5 minutes.
Sir, we can start. Rohit, sir.
Yes, sir.
Sir, we can start with the session. Basic.
Okay. Yes, Vikrant, sir.
Yes, sir.
Shall we start, Vikrant, sir?
Yes, sir. Am I audible?
Yes, sir.
Yeah. We can
Okay.
start.
धर्मेना युद्ध संपन्न साधवा सत्ववादिना तेषाय संगनी सुक्त विद्यते सर्व संपदा. Those who are armed with dharma and truth are the real noble ones. Their company brings true wealth. A very warm welcome to everyone. Today marks the seventh and the final day of Saamanjasya Skill and Capacity Program on Arbitration. Today's session, Parichay, stepping into the arbitrator's shoes. This day holds a special significance. After learning the essentials of arbitration, its foundations, procedures, enforcements, and justice, it's now time to step into the most crucial one role, that is of the arbitrator. Today, we not st- Today we start a journey of knowledge and step into a vision of responsibility, neutrality, and fairness that an arbitrator embodies.
On behalf of our organizing committee, I extend my heartfelt respect to our guiding light and inspiration, Dr. Ujjwala Bendale ma'am, Dean and Principal of our college, Vice Principal Dr. Jyoti Dharm ma'am, and IQSC Coordinator Dr. Jyoti Dharm ma'am. I also express my gratitude to my colleague Dr. Rohit Survase sir. It gives me immense pleasure to introduce our respected speaker for the today, Dr. Vikrant Yadav, Assistant Professor at MIT University. Dr. Yadav is a distinguished academician with a deep understanding of dispute resolution, contract law, and arbitration. His engaging teaching style, coupled with research oriented vision, makes him a guiding force for young students stepping into the world of alternative dispute resolution. His insights today will help us truly step into the arbitrator's shoes and see the process through the lens of responsibility, neutrality, and fairness. Over to you, Vikrant sir.
Uh, yes, good evening, everyone. I hope all of you have already enriched yourself with the process of arbitration, how exactly arbitration is carried forward, and the preparation of arbitration, post arbitration practices. I hope I have also been told that the arbitration problem has already been shared with you. So, as Sir has already briefed me, there are, I guess, five teams. So, we will start with the mock arbitration first. Then I'll talk about my observations in the mock arbitration, and then the final point will be the discussion on the draft, how exactly the ideal draft should be. Okay. So, I hope this course of action is fine, Rohit sir.
Yes. So we'll start with Team B. All the teams have to keep in mind you have 15 minutes for a presentation, 5 minutes for one council, 5 minutes for the second council, and 5 minutes for discussing your arbitral award. So as the teams are presenting their presentations, you have to submit your arbitral award so that it will be shown to the jury.
Hello.
So is Team B ready?
Yes.
Yes, Team B. Ansh, please keep a watch on the time.
Sure, sir. Team B includes Nishant Anand, Kaushiki Srivastav, and Shreya Raj. Yes, sir, we are ready.
Sure.
Okay, you can on your cameras and you can start. Yes.
So show on your cameras and the time will be started. I'll tell you. Okay. The time starts now.
Member of the tribunals, the council asks permission to initiate the proceedings.
Yes, you
Sir,
may.
the council asks permission to initiate the proceedings.
Yes.
Member of the tribunals, it is my privilege to appear as a counsel for the claimant, Global Tech Infotech, in this arbitration arising from the share purchase agreement concluded with Innovate Corp Limited. At its heart, this case is about trust, transparency, and contractual integrity. Sir, the background of the case lies as Global Tech agreed to acquire Innovate Corp for 1.2 billion USD under the SPA. The SPA expressly required Innovate Corp to disclose all material liabilities, litigations, and regulatory inquiries existing up to closing. Yet, Innovate Corp held back from providing Global Tech a serious competition law probe initiated 6 months prior by the country's Bees Competition Authority. This probe into suspected anti-competitive conduct poses substantial risk, heavy fines, reputational damage. So the first issue is, was the investigation material? Member of tribunal, as a competition authority, investigation is not a trivial matter. It affects how the company operates, how investors view it, and what liability it may face. Even at the early stage, such inquiries threaten the company's market credibility. This is to regulatory actions under commercial practice and Indian law. Materiality is not limited to immediate financial outflow. It concludes It includes any matter that would influence a reasonable investor's decision. Thus, the investigation was material and sound have been disclosed. Second issue is the breach of SPA. The SPA's disclosure obligation was absolute. All material liabilities, litigation, and regulatory inquiries must be disclosed. The Innovate Court failed to disclose scope. That is clear contractual breach. The third issue is indemnification. Because of this non disclosure, Global Tech now faces exposure to regulatory fines running into millions, significant legal costs, defending the proceedings, and irreparable reputational harm. The SPA was intended precisely to protect Global Tech from such hidden risk. The Innovate Corp must indemnify Global Tech fully. Thank you.
Mr. President and member of tribunal, it is my privilege to appear for the respondent Innovate Corp in this arbitration. This dispute is not about dishonesty or concealment. It's about whether a preliminary regulatory inquiry with no charge, no penalties, and no financial impact at the time was a material liability. The Innovate Corp was contractually obligated to disclose under sales and purchase agreement. We, we submit that it was not. The background of the case is that Innovate entered into sales and purchase agreement in good faith at the time of signing. The competition authority had not only initiated an inquiry, there was no finding, no charges, no penalties. The matter was publicly accessible information that any prudent buyer could have discovered with basic due diligence. Innovate did not hide anything. is disclose all known and material liabilities as required. Issue 1, Materiality. The sales and purchase agreement required disclosure of material liabilities, not every speculative or uncertain risks. At signing of the inquiry had no material impact on Innovate Corp's financial operation or ability to conduct business. Materiality must be judged objectively and not unproven. Preliminary investigation does not qualify. If global text interpretation is accepted, it would mean seller must disclose every rumor, inquiry, or informal notice, which was commercially impractical and beyond what sales and purchase agreement requires. Issue number two, no breach. There was no breach because the inquiry was not material. Innovate Corp had no duty to disclose. Therefore, there was no breach of sales and purchase agreement. Issue number three, due diligence failure. Global Tech is a sophisticated multinational corporation. It has access to significant resources. The competition authorities' inquiry was publicly available, yet Global Tech failed to uncover it. This failure can now be turned into a claim against Innovate Corp. The sales and purchase agreement does not excuse performance. Issue losses, but fine has been imposed right now. Find against us and in this situation. Unification cannot be so speculation. There is qualified loss. To deal what in it. Recession is extraordinary Indian law. It is available only where there is a fund fraudulent misrepresentation. It's no evidence of global stabilized commercial certainty. Conclusion. Member of the tribunal, the regulatory body was not material signing. Innovate Corp had and make no breach of global tax losses are purely cannot justify indemnification, which is inappropriate. We respectful request after declaring Innovate Corp has not breached the sales and purchase agreement, and the education should stand as
As my counsel said, that investigation was not material. Competition law investigation are always material, regardless of stage. They can cause reputational damage, restrict future operation, and reduce market value.
Uh,
10 minutes over, 5 minutes remaining.
okay, any observations from arbitrator, any clarification? Who is the arbitrator?
Shreya Raj, please present the arbitral award as the time is running out. You are already on the 11th minute.
Do I have to again start the argument because I was unclear at that time? Hello?
Yes, Vikrant sir, does she require to re-argue or it's okay?
It all depends on the arbitrator, sir. If the
So we'll have to take a
arbitrator wants any clarification, arbitrator can ask for the clarification. If not, then the arbitrator can directly jump on to presentation of an award. I
okay.
am
Yes,
simultaneously
arbiter.
noting down my observations, so I will convey them at the end.
Okay, yes.
In the view of our findings, the tribunal decided as follows. Invotech Corps Limited breached the SPA by filing a disclose the material regulatory investigation pendings at the time of SPA signing. And the Global Tech Incorporate is entitled to indemnification for the direct losses, including fines, legal fees, and reputational damage, reasonably proven to result from the regulatory investigation and invoke corp not disclosure. Global Tech Incorporate may elect either to uh, resign the acquisition and receive a return of the purchase price of 1.2 billion, or continue with the acquisition subject to indemnification for losses as per clause 2. The tribunal rejects Invotech Corp Limited claims that Global Tech due diligence failure absolve it from the breach. The cost of the arbitration shall be borne as decided separately.
Okay,
Should I have to mention the direction?
if you have covered them in the award, then please mention it.
Sorry, sir, I can't hear your voice.
I said that if you have covered the directions in the award, then you can share them. Otherwise, it's fine.
Okay, sir. The direction include the parties shall submit evidence of actual damages and losses arising from the regulatory investigation within a specified time, following which the tribunal will determine the quantum of indemnification if the acquisition is not resided. If global tech elected recession, the parties shall agree on mechanism for returning the purchase price and unbinding the transaction. This award is final and binding on the parties. That's also.
Okay, Rohit sir, I know I have told you that I will give the comments at the end, but let me give the comments right now only so that the next groups can benefit from it.
Yes,
Because ultimate goal is that
surely,
they
sir.
should understand how exactly the arbitration happens. Okay, I completely
Yes, sir,
understand that
surely.
the time is very less at the hand. They are having only 15 minutes. But even in this 15 minutes, what you are supposed to do is that the arbitrator should anchor the entire proceedings. Swearaj. Okay, so you should start the proceedings, you should introduce yourself, you should ask the parties to introduce themselves, and then the claimant will start presenting their claims. The respondent will respond, and then if any cross questions are there, the respondent and claimant can ask the cross questions and get, excuse me, and get the answers. Once that is done, the arbitrator should again proceed for presenting the award. In award, one most important thing that you have to do is that the losing side, if you feel that the award is going completely in favor of one party, then the arbitrator should give detailed reasoning, particularly as to why you are not giving decision in favor of party B who has lost the case. Okay, because the losing party is always of the opinion that our opinion might not have been considered well by the arbitrator or might not have been well received by the arbitrator. So they might have the element of biasness in their mind that arbitrator has acted in the biased manner. He did not give us a proper attention. So for that reason, you should give reasons, particularly addressing the arguments given by the losing side. Okay, so that balances the opinion. Even if I have lost the case, fine, arbitrator has addressed my concerns, arbitrator has understood my side. So always give some reasons as to why the decision went in favor of other party and why it was not in your favor, and always be make it sure that those reasons are based on the legal grounds, this governing law. Okay, like in this case, the governing law was of an Indian law. So I don't mind, or I would rather expect that the arbitrator will mention few of the provisions of law and then state as to why exactly that decision was given. Okay, and most importantly, every time, since we are in the online mode, in ODR particularly, you need to make sure that your content is well received by the other party. Okay, why? Because sometimes it may happen that in between the internet connection is lost, so it may not. It may happen that the other party might not have heard you properly. So always keep checking as to whether the other parties are receiving your content or not, whether they are able to see you or not. So always keep on checking. Whoever is talking, keep on checking whether you are visible, audible or not. Okay. Always be courteous to others. Arbitrator should convey to both the parties before starting his award that I thank both of the parties for presenting their opinion, and I have well received their submissions. Now let me proceed with presentation of the award. So that is how you need to be more formal while presenting the contents, both the parties as well as the arbitrators. Okay. So, sir, we can now move on to the next group.
Yes, sir. So team C.
Hello, um, I'm Shravan Verma from Team C. Am I audible?
Yes, you are audible.
Yes.
Good morning, everyone, honorable members of the tribunal. My name is Shravan Verma, and I represent the claimant, Global Tech and Corporations. This case arises from a fundamental breach of share purchase agreement valued at 1.2 billion US dollars. At the heart of the dispute, it is very simple yet a very critical issue. The respondent, Innovate Corporation Limited, failed to disclose a material regulatory investigation that existed at the time of signing of the SPA, the share purchase agreement. That omission, deliberate or otherwise, has profound consequences on the fairness and validity of the transaction. Allow me to outline the claimant's position. First, the SPA was unequivocal. The Innovate Corporation undertook a clear contractual obligation to disclose all material liabilities, pending litigations, and regulatory inquiries. These warranties were not ornamental. They are the foundation upon which global tech made its investment decisions. Second, at the time of signing, Corporation was already under an active investigation by the competitive authority of country B. This investigation carried the risk of substantial monetary penalties and several operation restrictions, risk that no prudent investor would ignore. Yet, the critical fact was withheld. By doing so, the respondent breached the SPS disclosure obligation and misled Global Tech into entering the transaction on false premises. The conduct squarely falls within fraud and misrepresentation, rendering the contract voidable at the option of the aggrieved party. The impact is undeniable. The global tech paid a price for a business that was worth far less than represented, burdened with undisclosed regularity and exposure. Accordingly, the claimant respectfully seeks the following from the tribunal: a declaration that Innovate Corp has breached its obligation under the share purchase agreement, indemnification for legal and professional costs incurred to date, and any penalties or damage that may crystallize due to undisclosed investigation. Alternatively, the rescission of the share purchase agreement and restitution of the purchase price, restoring Global Tech to its pre-contractual position. Members of the tribunal, Global Tech entered this SPA in good faith, trusting the integrity of Innovate Corp disclosures, and the trust was betrayed. Silence was used as a shield to hide a material fact, a fact that strikes at the very heart of the bargain. The tribunal is now tasked with upholding the principle of fair disclosure and contractual integrity. We respectfully submit that the relief we seek are not only justified, they are also essential to restore equity in this transaction. Thank you.
Uh, Good morning, members of the tribunal. I'm unable to turn on the video because it is showing as unavailable. If that is all right, may I continue?
You
Hello.
can continue, Anish.
Okay,
Yes, you may,
thank you,
but
sir.
you're echoing a lot. You're echoing a lot.
Okay. Uh, Hello, sir. Is my voice clearer now?
Yes, beta. Yeah, you can.
Good morning, members of the tribunal. I appear on behalf of the respondent, Innovate Corp Limited. At the heart of this case is the question whether preliminary speculative regulatory inquiry can be treated as a material liability under the SPA. We respectfully submit that it cannot because at the time of signing, no charges, penalties, or restrictions existed. The investigation was merely at its early stage and therefore not material under the SPA. The claimant suffered no actual loss. Indemnification cannot be granted for speculated harms. Further, the claimant had every opportunity to discover the inquiry, which was publicly available information. Having failed in its due diligence, it now attempts to shift the burden entirely onto the respondent. That is not what the law or commercial fairness requires. Accordingly, the respondent seeks a declaration that it did not breach the SPA and a dismissal of claimant's request for indemnification and rescission, confirmation that the acquisition stands completed. Member of the tribunals, this case is not about fraud or concealment, but rather about an acquirer attempting to rewrite the bargain it struck. We respectfully ask the tribunal to reject the claimant's claims in full. Thank you. Uh, so, since our third member was not participating in the um, trial today, we would we would like to talk about the tribunal's decisions ourselves. The tribunal declares that Innovate Corp Limited breached the SPA by failing to disclose a material regulatory investigation. Global Tech Incorporated is entitled to indemnification for legal costs already incurred in connection with the investigation. Furthermore, the claims for respondent reputational damages and speculative fines are dismissed without prejudice to renewal if losses crystallize. Claim for rescission of the SPA is dismissed. Each party shall bear its own legal cost, arbitration costs to be shared equally. All the other claims and counterclaims are dismissed. Thank you, sir.
Again, same thing. I understand that arbitrator was could not be present in this session, but the introduction should start from arbitrator, then the claimant, then the respondent, and then clarifications and the award. So this is the flow that should happen. In traditional arbitration, I completely understand that now we are having a limited time, but in traditional arbitration or in the offline arbitration or in any arbitration, usually in between the evidences are also taken. So the sequence is like first you start with the claim, then the defense. In claim and defense, the written statement should also accompany the list of evidences, the details of the evidences, documents, everything, and then The supplementary submissions may be done by the parties with the permission of the arbitrator, and uh, thereafter the parties uh, yeah, sorry. So thereafter, the parties will, uh, if required, may ask for the help of an expert. So in some arbitrations, there may be an arbitrator, and once the expert submits his report, then the arbitrator will finalize the draft of an award. While doing that, the arbitrator may have a clarification meeting. Some submissions made by the parties may not have been properly understood, or the interpretations might lead to two different interpretations. So, for the purpose of clarifications, the arbitrators may have the final meeting, clarificatory meeting, and then the arbitrators will take some time to draft the award, and then the draft will be presented to both the parties. Okay, that is how the flow goes. So, since we are now online and we are having 15 minutes, I'm again reiterating that the arbitrator should start the proceeding. Arbitrator should introduce himself or herself. Then the claimant should introduce himself or herself, and then followed by the respondent. Okay. Uh, Arbitrator should anchor all the proceedings. Arbitrator is acting like a judge, not a judge, but is acting like a judge. So he or she should control the entire proceeding.
Thank you, sir. We will make sure it doesn't happen again.
No, I'm not pointing out the mistakes. See, everyone is learning. Even I'm not. I cannot claim that I'm a perfect person in the field of arbitration. These things, the arbitration differs from place to place. The practices differ from place to place, institution to institution. So we cannot say that with a blanket rules of law that this exactly is what the arbitration is and this is how it should happen. No, it changes. The practices changes from place to place. But the common observations are that the arbitrator is the one who controls the proceeding, because it may happen at sometimes that the parties are having the very adverse opinion. So in that case, the arbitrator has to be in a controlling mode, and that becomes very difficult job, particularly in the online dispute resolution process. So arbitrator needs to be very vigilant and very proactive and involved into the arbitration. So this is just a suggestion so that you will keep in mind for the future practices. This is I'm not pinpointing the mistakes, or I'm not pointing out that this is where you have committed uh, a blend. No, these are just the learning stages for us also, and hence we are mutually learning from you also. So I'm also learning few things from you. So it is a mutual learning. Nothing, not like someone is pointing the mistakes and then you have to improve. Fine. So we can proceed to the next group. Sir.
Is Team D ready? Team D. Prachi Patel, Abhyuday Chauhan, Richa Sethia.
Shall I start?
Please follow the cue stated by Sir, as the arbitrator will start, followed by the claimant, and followed by respondent.
Okay. Good morning, distinguished parties, and my all our audience. I welcome you all to the arbitral proceeding convened under the auspicious International Chamber of Commerce with the seat of arbitration in Geneva, Switzerland. We are assembled here to determine the dispute between Global Tech and, the claimant and Innovative Corp Limited. The respondent arising out of the share purchase agreement executed between the parties. As per the arbitration agreement contained in the SPA, the tribunal has been duly constituted and we proceed with the ICC rules of arbitration. The matter before us concerns the acquisition of Innovative Corp Limited by the Global Tech valued at 1.2 billion. Following the transaction, the Global Tech alleges that Innovative Corp failed to disclose the significant regulatory investigation by the Competition Authority of Country B into alleged anti-competitive practices. The claimant contends that the such non-disclosure constitutes a breach of material compliance with the SPA and seeks indemnification for potential losses, legal costs, and reputational losses. Alternatively, it seeks rescission
of the acquisition and return of the purchase price. The respondent, on the other hand, maintains that the investigation was not immaterial at the time of signing, argues that the global tech failed in conducting sufficient due diligence, and submits that no breach occurred, thereby asserting the acquisition should stand as completed. Now, the issues we have today: whether the regulatory investigation constituted a material liability requiring the disclosure of under the SPA, whether the innovative corp breached the SPA by failing to disclose the said investigation, whether the global tech is entitled to indemnification for the potential losses, whether the alleged breach, if established, warrants rescission of the accusation, or whether the accusation shall stand as completed. Now, the tribunal shall ensure that both parties have full and fair opportunity to present their respective cases. We remind parties that our role is educate impartially in accordance with the governing of law while ensuring adherence to due process and principles of natural justice. With these observations, we now invite the parties to proceed with their opening submissions. The claimant shall present its first case, followed by the respondent. Thank you.
Honorable members of Tribunal, I rise on behalf of Global Tech Incorporated to demonstrate that Innovate Corp's deliberate failure to disclose a regulatory investigation by the Competition Authority of Country B is a breach of the share purchase agreement, a breach of trust, and a breach of fundamental principles of good faith in international commerce. This case is not a mere technicality, it is about a material omission that struck at the heart of the transaction. An omission that exposed global tech to enormous financial, regulatory, and reputational risks. My claims are as follows. The SPA required disclosure of all material liabilities litigations, and it specifically mentions the inquiries before closing. An ongoing investigation into anti competitive practices is inherently material. It threatens fines, sanctions, and reputational harm, and also potential restrictions on Innovate Corp's business. Moreover, by omitting disclosure, Innovate Corp breached express contractual warranties. Innovate Corp's duty was to disclose accurately and exhaustively instead of concealed. This is a breach both in law as well as equity. Moreover, Innovate will argue that the global tax should have discovered the probe via due diligence. But this is very irrelevant. The law is clear: warranties allocate risk to the seller. Due diligence does not absolve a seller from the consequences of its non disclosure. Moreover, the SPA's indemnity clause applies precisely to this situation. The global tech is entitled to indemnify for regulatory fines, the potential penalties arising from the antitrust inquiry, also the legal costs, ongoing defenses of regulatory proceedings, and also the reputational damages. The court have recognized reputational harm as compensable in commercial context in several precedents. And if the tribunal finds that the non-disclosure goes to the roots of the SPA, the global tech is entitled to rescission. While ICC tribunal often prefer damages, rescission remains a valid remedy where concealment undermines the very foundation of the SPA. The Global Tech respectfully requests this tribunal to declare that Innovate Corp breached the SPA by failing to disclose the antitrust investigation. The second relief Global Tech would like to request is order Innovate Corp to indemnify Global Tech for all the losses, including regulatory fines, legal expenses, and reputational harm. Alternatively, resign the acquisition and restore the purchase price of 1.2 billion US dollars. Honorable member, at its core, this case is about honesty in commercial transactions. As the ICC tribunal held in Solvay versus Edison, Sellers must disclose all liabilities accurately and exhaustively. Innovate Corp failed in that duty. To excuse this failure would erode trust in cross-border mergers and acquisition and reward concealment. Global Tech therefore praised that this tribunal uphold contractual integrity, protect commercial fairness, and grant the relief sought. Thank you.
Uh, I'm sorry I'm intervening in between, but Rohit sir, are we
Honorable,
recording this meeting?
Honorable member of the tribunal, it
Just a
is my
second.
privilege to
Just
present
a second.
Innovate Corp's
Prachi,
claimant
just a
seeks
second.
to rewrite.
Prachi,
Prachi, wait.
Prachi, just a second. Just a second.
Speak slowly.
Yeah.
Okay. Why
Just a
I
minute.
have intervened is because I just want to
Yes,
know
sir.
whether we are recording the meeting. If not, my
Yes, sir.
request to you is
Huh.
that you call all these three team members again in the physical mode. Let
Huh.
them perform again
Okay.
and then record entire proceedings because I think this is by far the best presentation that I have seen. Let others also know how exactly it happens. So it is by far the best, and I would rate it almost 90 out of 100. Given the time constraint, they are almost taking every point. So please call them in case we haven't
Yes.
recorded. Please call them again and record everything. I
Yes,
guess we
sir.
are
Sir,
recording.
No, sir. The meeting is.
we are recording the meeting, sir.
Yes, fine, fine. So
So we'll
just
have this.
crop their presentation and show it to everyone again.
Okay.
Yes, surely, sir. Surely,
Yeah.
sir. Yeah.
Now, next presenter, be slow, take your time. Even if you exceed time, fine, let it be. Because it need not be that all five should present today only. If required, I'll join again tomorrow. But let there be a justice with all their efforts that they have.
Yes, sir. Thank you, sir. Honorable member of the tribunal, it is my privilege to present Innovate Corp's case. The claimant seeks to rewrite the bargain it struck in the share purchase agreement by alleging breach for non-disclosure of a preliminary regulatory inquiry. We submit that no breach occurred. The investigation was not material at the time of signing. Global Tech, an experienced multinational, failed to perform adequate due diligence, and the relief sought is speculative and commercially disproportionate. The SPA obligated disclosure of material liabilities, litigation, and inquiries. At the time of signing, no charges were filed. The inquiry was preliminary, speculative, and not a liability. Global Tech is a sophisticated multinational with ample resources to conduct thorough due diligence. The regulatory inquiry was a matter of public record. Had Global Tech exercised diligence, it could have discovered it. Internationally, ICC tribunals often recognize that buyers cannot abdicate responsibility for diligence where information is publicly accessible. Indemnification under the SPA can arise only upon actual crystallized losses. Global Tech's claim rests on anticipated fines and reputational harms, but no penalty has been imposed. Rescission of a $1.2 billion acquisition in an extraordinary remedy disrupting markets and undermining investor confidence. Even if the tribunal finds breach, the proper remedy is limited damages and not unwinding the acquisition. Here, Innovate Corp has made no false statement. It simply did not disclose a preliminary inquiry that was yet not a liability. The SPA cannot be stretched to cover every potential regulatory development. In light of the foregoing, Innovate Corp respectfully requests this tribunal to declare that no breach of the SPA occurred. The investigation was not material at the signing date. Dismiss Global Tech's claim for indemnity and recession as they are speculative and disproportionate. Affirm that the acquisition stands completed, preserving commercial certainty and contractual integrity. Honorable member, this tribunal is asked to decide not only on legal obligations but on principles that ensure fairness and certainty in international commerce. To impose liability for a preliminary, non material inquiry, one that Global Tech could have discovered, would upset the balance of responsibility in mergers and acquisitions worldwide. We therefore urge this tribunal to uphold the sanctity of the bargain, deny the claims, and confirm the validity of the acquisition. Thank you.
Clement, I have one questions for you.
Oh, yes.
Okay. You argued that the investigation was material. Can you provide specific evidence of how the existence of this regulatory probe would have altered your decision to acquire innovative core?
First of all, the ICC, in its case Solvay versus Edison, it has specifically mentioned that the seller must disclose material liabilities accurately and exhaustively. And also, uh, the inquiry is still in process, but the duty of disclosure, even if it is a public information, the duty of disclosure is there on the respondent side. And if they do not disclose the material information, then there is no point of that law, that particular provision. Okay.
So I would like to
Yes.
defend my point here. Can I, sir? Can I speak my?
Okay, sure. You can take one
Yes,
sentence.
sir. Thank you, sir. Unlike Solvay versus Edition, that is ICC case number 18666, where extensive contamination was proven and undisclosed, here no regulatory finding or penalty existed. To equate a routine investigation with a material liability would expand disclosure obligations beyond their contractual intent.
So I have one question for you as well, the respondent party. Did Innovative Corp's management seek legal advice on whether the investigation needed to be disclosed under the SPA? Yes or no?
So, hello, am I audible?
Yes, you are.
Actually, yes.
So don't you thought that it would hamper the further due diligence activities?
So the company should have taken due diligence since it is a multinational company, and a transaction as big as this is being conducted. Along with that, the profit of the share that is being the company will be enjoying. The company should have obviously taken due diligence. The company was negligent here, and it is upon the company to take the the standard care that should be required.
Okay, ma'am. One more last question to you. If you believe that the investigation was so immaterial, why not disclose it and let Global Tech make its own assessment of that risk?
Sir, the charge during at the time that we made the agreement, there was no sign. At the time of signing, there were no charges that was filed, and the inquiry was preliminary and not a liability during that time.
Okay, ma'am. Fine.
Also, I would like to put up one point. Even if the information was public, it is the duty of the party to disclose it if it directly affects the transaction. And it does. If the anti-competitive practices are proved in future, it will definitely affect the business in the whole country B.
So to for this, I would like to say that it was clarified in Satya Jain versus Anish Ahmed Rashdi case that materiality requires certainty of impact and not just mere possibilities. And during that time, it was just mere possibility and no impact um, as such was had happened during that time.
So, okay. Thank you, both parties. May I proceed with the arbitral award?
Yes, sir.
Yes.
Okay, thank you. Now the tribunal has rendered its final award in matter after careful consideration of the facts, arguments, and applicable law. We have determined that Innovative Corp Limited breached its obligation under the share purchase agreement by failing its disclose the ongoing regulatory investigation. At the same time, the tribunal has found that the rescission of the transaction would be disproportionate and disruptive to commercial certainty. Accordingly, we have directed the Innovative Corp to indemnify Global Tech for actual legal costs and penalties arising directly from the investigation. While dismissing the claim for reputational damages, the award presents a balance between contractual duties and need to preserve the integrity of transaction already concluded. We trust that both parties will respect the finality and binding nature of this decision under the ICC rules of arbitration. Thank you.
Thank you so much, sir.
Everything was perfect as I already told you. The only thing is arbitrator should introduce in the initially Abhyuday had in detail told that this is the matter under the aegis of ICC and hence we will be governed by the rules of ICC. Everything was fine. The only important element that you missed out is that the arbitrator should convey it specifically that the arbitrator is neutral and has no conflict of interest to declare. Okay. And then the arbitrator shall also convey that I am not a judge, but the decision of mine, the arbitrator or the arbitral tribunal, will be final and binding on both the parties. These two important elements must be communicated by the arbitrator in the first meeting. Second thing is that the parties who are presenting, both the parties have relied very well upon the precedents and the international law. But don't forget that this is the arbitration which is governed by the Indian law. So you should also make it a point that you are referring to the governing law in between whenever necessary. And third thing is, if the parties have finished their submission, arbitrator should not say that may I present the arbitral award. Arbitrator should say that if the parties have finished their submissions, the tribunal will proceed with the award. Okay. So these are the minute things that you have to check. So we can proceed with the next group. Sir.
Yes, sir.
You, sir.
Thank you, sir.
Team A, are you ready? Kunal Deshmukh, Prashant Garg, and Anmol Singhal. Sir,
Am I
am I
audible and
audible, sir?
visible?
I think Shivali has replaced Kunal in this group, so Shivali will be there, and Prashant and Anmol will be there.
Sure, sir. So
Yes, sir.
Shivali Bhosle, Prashant Garg, and Anmol Singhal.
Yes, teams, you may start.
Yes. Good morning, the distinguished parties. Good morning, distinguished parties. Uh, to the arbitration between the dispute to the arbitration that arises from a dispute between Global Tech Incorporated, the claimant, and the Innovate Corp Limited, the respondent, which was under the share purchase agreement governed substantively by the law of India. The seat of arbitration is Geneva, Switzerland. The tribunal affirms its strict adherence to the ICC rules of arbitration of 2021, which would govern the procedural aspects of these proceedings. In conducting this arbitration, the tribunal is committed to upholding the fundamental principles of fairness, impartiality, and due process in accordance with the principles of natural justice. We would like to inform both the parties that they will be provided equal and full opportunity to present their cases and respond to the opposing parties' submissions. I now invite claimant of the Global Tech Incorporated to make its opening submissions.
Yes. Global Tech believes that investigation by the corporation authorities of the country B was very important. This probe looked into whether Innovate Corp was doing
things that limited fair competition. Such an investigation can lead to big fines and restrictions from on the businesses. Since the since the investigation started 6 months before the agreement was signed, it was ongoing and not just a small or unimportant matter. Global Tech thinks that Innovate Corp should have told them about this because knowing this would have affected the decision to buy the company. The share purchase agreement clearly said that Innovate Corp must tell Global Tech about all the important liabilities, legal problems, or investigations up to the closing date. Not telling Global Tech about this probe breaks the agreement. Even if investigation was just starting and no formal charges have been made, it was still important information. Innovate Corp cannot decide what by themselves what is important or what the contract required, whether the contract requires full disclosure or not. Because Innovate Corp did not tell Global Tech about the investigation, Global Tech might face fines, legal costs, and damages to their reputation. These losses can these losses can happen because of Global Tech's breach of contract. So Global Tech has the right to be paid back for these losses according to the contract. This is fair because Global Tech had known about the investigation. They might have not bought Innovate Corp or were paid. Since Innovate Corp did not tell Global Tech about some very important information, this breaks the contract deeply. In such cases, Global Tech can ask the tribunal to cancel the acquisition and get the money back they paid by the way of recession. Innovate Corp says that Global Tech should have done more investigation themselves and could have found out about the probe by public sources. But this is not fair nor correct because Global Tech has agreed to tell Innovate Corp has agreed to tell Global Tech about important matters. Sometimes companies keep regulatory investigations confidential. So Global Tech would have not found out easily. Innovate Corp cannot use Global Tech's supported failures in due diligence as an excuse for not telling the truth. All in all, Global Tech respectfully requests the tribunal to find that Innovate Corp breached the share purchase agreement by withholding the material facts, order indemnification for all the losses caused by alternatively revoke the acquisition and require the returns of the purchase and reject the Innovate Corp's claim that due diligence excuses their non-disclosure.
Um, the respondent, you can start with your submissions. You are muted.
Hello, am I audible? Audible? Am I
Yes,
audible?
you are audible.
Okay. Honorable member of the tribunal, today I address the claim brought by the Global Tech concerning the share purchase agreement governed by Indian law regarding our client. Innovate Corp Limited, my submission focus on three clear lines: materiality, due diligence, and consequences. Materiality. Materiality of the regulatory inquiry. The heart of the Global Tech claim is that Innovate Corp breaches the SPA by failing to disclose a competition authority investigation. The decisive question is whether this was an material liability under the SPA.
At the time of the signing off, this was a preliminary inquiry. No charge, no penalty, nor any finding existed. Indian contract law and M&A practice require disclosure only of the material issue likely to affect the transaction core value. Court and arbitral precedent make it clear that a mere regulatory inquiry without substantive progress or negative outcome does not meet this threshold. Innovate Corp bridge to SPA. Innovate Corp fully complied with his obligation as the SPA required disclosure only of material matter, nor any any and all ongoing background inquiry. At signing, nothing had eventuated that would qualify as material requiring disclosure. There is also no fraud or bad faith. Section 17 of Indian Contract Act only trigger liability for non-disclosure whether there is an active duty and intent to conceal a material fact, neither of which apply here. Global Tech entitled to indemnification for potential losses. It is well established, especially in cross-border and M&A, that buyer must perform adequate due diligence. Here, information about the investigation was in public domain. Global Tech had a duty and an ample opportunity to discover this before the transaction. As a recent Indian M&N case law and reputable practice guides make plain, a party cannot willfully ignore public fact and later demand recession or indemnification. Their claim is essentially a sandbagging, which is not favored in Indian and or international jurisprudence. No right, no should be acquisition be rescinded due to alleged breach or should it stand as completed. Because there was no breach and because Global Tech failed in its own duty of care, their claim for indemnity damage or unwinding the acquisition must fail. Indian law is strict. Only a proven material misrepresentation or undisclosed material adverse change can warrant such relief. The acquisition must stand as a complete upholding certainty and sanctity of contract, particularly under ICC arbitration principle and respecting the seat at Geneva. We respectfully request the tribunal declare there was no breach, dismiss all Global Tech claim and order that the transaction stand. Innovate Corp also request appropriate recovery of legal costs due to unfounded nature of these proceeding. No material fact was suppressed, no legal or contractual breach was occurred, and Global Tech own choice foreclose any relief. Thank you. Thank you.
Okay, my question is with the claimant. I want to confirm or clarify whether there was a specific provision disclosure of any like similar legal proceeding. What would happen?
Can you
They
please repeat?
affected
The
any
voice
of
was cracking.
the audible? Hello, I'm audible.
Yes, yes.
I was asking, I have one clarification to make from you that was there any specific or explicit provision in in your share purchase agreement between you and the respondent about the initiation of any legal proceedings or investigations like the same was done by the competition authority in the country of like the respondent?
The main point that we would like to hold over here is the due diligence that any purchaser is supposed to perform is not binding, whereas the disclosure of material facts is always binding in any type of contract. It is the most essential thing in any contract. So, disclosure of not doing disclosure of such important facts is
considered that there was any Hello, am I audible?
yes, yes, Your Honor.
Do you have any counter questions to the respondent to his answer?
That's the sole question that we have. That is disclo- is due diligence more binding or is disclosure of material facts more binding?
Respondent, would you like to answer?
Uh, due diligence, I think due diligence is more binding.
Any other suggestions the party would like to make?
It's clearly in our rules that disclosure of material fact is the most important thing. So I am done with my argument. For any contract, may it be a share purchase agreement.
Okay, so having carefully considered the submissions and arguments made by the party, the tribunal comes to the following conclusions. First, tribunal finds that the Innovate Corp, the respondent, has breached its disclosure obligations under the share purchase agreement by failing to disclose a material regulatory investigation by the competition authority of country B. Second, the claimant, that is Global Tech Incorporated, is entitled to indemnification limited to the actual and reasonable legal costs incurred defending the regulatory investigation. The claims for speculative fines, reputational harm, or rescission of the acquisition are dismissed. The acquisition stands valid and binding. Also each party shall bear its own legal costs and expenses and the cost of arbitration, including the tribunal's fees and ICC administration fees, shall be split equally. This award is final, binding, and enforceable under the ICC rules of arbitration. The award is hereby issued in Geneva, Switzerland on this 24th day of August 2025. Thank you.
Okay, good. I guess we are done with all teams, sir, or we still have teams?
Sir, one last team is remaining. Team G is remaining.
We'll go ahead with them.
Okay. Team G, Raghav Patak, Devesh Gade, and Yash Dabde.
Hello.
You are audible, right?
Okay, sir. So I can't see Devesh and others. Are they here? Sir, are they here? Devesh and others.
Uh, I guess they were here. Yes, they are here. Okay.
Hello, Raghav.
Where is Yash?
So the time has already started. Please begin your proceedings.
Good evening, everyone. My name is Raghav Pathak, and I am appointed as your arbitrator. This arbitration is conducted under ICC rules, seated in Geneva. And the substantive law applicable here is Indian law. In this hearing, this hearing will be conducted fairly, and the both parties will be fully heard. My decision is binding in both the parties as per the agreement. Issue for the determination in this arbitration are was the regulatory investigation a material liability that should have been disclosed under the SPA. Second issue, did Innovate Corp breach the SPA by failing to disclose the investigation? Third issue is Global Tech entitled to indemnification for potential losses. Fourth issue, the should the acquisition be rescinded or shall it stand completed? Fifth issue, what is the effect of Global Tech's alleged failure to conduct with due diligence? The flow of today's proceeding will be, we'll first hear opening statement from both the parties. After that, we'll proceed to the presentation of facts, followed by the arguments on key issues. The tribunal may ask clarifying questions during the proceeding. At the end, each party will briefly make closing submissions. I request the councils remain respectful, concise, and avoid interruption when the other side is speaking. We shall now begin with the opening statement. Counsel for the claimant, Global Tech Incorporated, you may proceed with your opening statements.
Thank you, learned arbitrator. This dispute is about the trust, transparency, and compliance. Global Tech entered into $1 billion acquisition on the clear contractual assurance that Innovative Corp would disclose all material liabilities. Instead, Innovative Corp concealed an ongoing antitrust investigation, a risk so fundamental that it undermines the entire basis of the bargain. We respectfully submit that this is concealment constitutes a breach of the SPA. With that, I'll end my opening statement, land arbitrator.
Okay, thank you, counsel. Now, the counsel for respondent, Innovative Corp Limited, you may proceed with the opening statement. Easier.
Thank you, learned arbitrator. Members of the tribunal, this dispute is not about concealment or fraud, but about how far disclosure obligations should extend in an international acquisition. Innovative Corp submits that it fulfilled its obligations under the SPA as the regulatory inquiry in question was neither material nor crystallized at the time of signing. To demand disclosure of every speculative or preliminary inquiry would place an unreasonable and impractical burden on businesses. Further, Global Tech and its vast resources had ample opportunity to conduct thorough diligence and cannot shift the consequences of its own commercial oversight into Innovative Corp. With that, I'll end my opening statement, learned arbitrator.
Thank you, counsel. We will now move to the presentation of facts. Counsel for the claimant, please walk us through the factual background of the case, including the circumstances of alleged disclosure.
Uh, Thank you, arbitrator. One of our clients, Global Tech Corporation, it is a multinational company. It also has outstanding technological base in country A, and it has entered into an share purchase agreement with the Innovative Corp Limited, which is company based in country B. And here Global Tech has decided to acquire 100% of share value of Innovative Corp Limited. This deal worth was 1.2 billion, and it was expected that enable Global Tech to consolidate its market in country B and increase technological capacity. Uh, SPA contained a statement to effect that Innovative Corp was under obligation to disclose all material facts, litigation, and regulatory inquiries up to a certain closing date. Contractual, the contract bit all the agreement has also arbitration clause where dispute arising, SPA will be settled by arbitration. Here it was a issue where Innovative Corp, however, going through an investigation was not uh, mentioned to the global tech and failed to do so, which arise too many dollar fines. So here I complete my facts.
Honorable arbitrator, may I proceed with my facts?
Yes.
Thank you. Uh, Innovative Corp Limited, a leading tech company in country B, entered into a share purchase agreement, that is SPA, with Global Tech Incorporation for the acquisition of its shares valued at USD 1.2 billion. The SPA required disclosure of material liabilities and ongoing litigation. At the time of signing, a regulatory inquiry by the Competition Authority of country B had just begun, remaining at a preliminary stage with no charges or penalties issued. Innovative Corp, acting in good faith, did not view this early stage inquiry as a material liability. Importantly, information regarding the inquiry was publicly available, and Global Tech, being a sophisticated multinational, had the opportunity and resources to discover it during due diligence. Thank you.
So I will start with my issues. The issue one I will present that was the regulatory prop is a material flag, and antitrust prop is not a routine inquiry. It threatens fines, operational restriction, and reputational damage. Even at an early stage, such investigation has chilling effect on market confidence. Therefore, the prop was clearly a material liability that fell squarely within the SPS disclosure obligation. Over to you, Council.
Sir, you're not audible.
Raghav, you are audible, but the voice is very low. Yes, you can proceed with your submission.
Thank you, sir. My arguments are as follows. Investigation, not material, at signing SPA. At the time of SPA, the electric inquiry was preliminary with no charges or penalties imposed. Mere initiation of inquiry without findings or sanctions does not amount to a material liability requiring disclosure under the SPA. Over to you, Counsel.
The SPA, no, sir.
It's okay. They wish proceed with the second.
Uh, I will I will put my issue to which was SPA impose a strict obligation disclose all material liabilities, litigation, and regulatory inquiries. Innovative Corp knew of this prop 6 months before signing a non-disclosure breach. Due to disclose is positive, it cannot be shifted to the buyer. Thus, Innovative Corp breach fundamental representation of SPA. Over to you, Council.
The number two argument that I'm going to make is the SPA requires disclosure of material liabilities, litigation, or regulatory actions. A speculative investigation cannot qualify. Innovative Corp fulfilled all contractual obligations in good faith, hence there is no breach of disclosure or obligations as such. Thank you.
Yes, you are audible.
Hello. Okay, okay. Sir, can we do it again? My phone died.
Not required. We can proceed with the next things.
Okay, sir, guide me where we are in the process.
Arbitrator, I am on issue 3 right now. So I
Okay,
am representing
so
issue. So
okay,
the issue 3 is losses which will be through fines which is foreseeable, and
okay,
all the legal expenses and reputational damage.
okay. Thank
Here
you, counsel.
here
Okay, thank you, counsel.
indemnity
Well, yeah, you may speak now. Speak.
Here indemnity provision exists precisely for this risk. By breaching, Innovative Corp made itself liable to indemnify Global Tech fully.
Thank you, counsel. Now the counsel for respondent may address issue 3.
Sure. The regulatory inquiry was publicly available information. A sophisticated multinational company like Global Tech, investing $1.2 billion, had the resources and responsibility to discover it. Their failure to detect it cannot be shifted onto Innovative Corp. Hence, it is a failure from their end. That's it.
Thank
Uh,
you, counsel. Now, counsel for the claimant can address issue 4.
okay, thank you, arbitrator. Should the acquisition be decided, non-disclosure of $1 billion liability is not a minor irregularity. It goes to the root of the contract. According, tribunal may order rescission of the SPA and refund the purchase price with interest. Effect of global tech's due diligence. Innovative Corp argues the information was public. That is irrelevant. The contractual duties to disclose independent of the bias diligence. Public availability does not excuse a party from disclosure obligations, especially where it comes to the $1 billion acquisition. Therefore, global tech diligence cannot be cure Innovative Corp's breach.
Thank you, counsel. Now I would like to hear respondent
Was
on
the
issue 4.
argument for number 4. Global Tech claims reputational and financial damage are speculative since no penalties or restrictions have been imposed. Indemnification cannot be sought for uncertain future or hypothetical losses. That's it. Arbitrary.
Okay, I would like to ask a question to you on issue 4. What would be this? What would registration cost commercially if it happens?
Would you please repeat the question? Uh, the
What would this registration cost commercially if it happens?
you're not. Can you please repeat it again?
Uh,
Very sorry.
I I want to ask you on issue 4 exactly what this
Okay.
registration would cost commercially to the respondent. Can you tell me?
It would undo a 1.2 billion acquisition, destabilize markets, and is commercially impossible.
Oh,
See, your screen is frozen and you
okay.
cannot record. Yeah.
Okay, that's fine. I mean, there must be some technical issue on his part. I have heard both the parties, and
Thank you.
you have handled the technical glitches on part of arbitrator very well. Practically, if such kind of things happen, the parties may get into touch with each other, even with the arbitrator through the telephonic conversation, and then they may agree to have a meeting sometimes in future. Okay, so the meetings may be suspended, and then the subsequent sessions may be arranged as per the convenience of both the parties. The arbitrator has to arrange for the next meeting. So these things do happen in the online presentation, and it is good that it has happened because
Thank you.
this is how the things are to be handled by both the parties. Okay. One more thing that I liked about the presentation of both the parties is that both of them
Thank you, respondent.
started with a
Now,
gratitude and ended with the gratitude, because saying thank you at the beginning or at the end conveys that you have started and also conveys that you have stopped presenting your side. Because many times I have observed during this session that the claimant has presented but the other party didn't understood it in time that the claimants submission are now over. So saying thank you at the end conveys to the other party that yes, their submissions are over, now they can start. So always have a gratitude expressed at the beginning of presentation as well as at the end of presentation. Raghav, I already have your award. I have gone through the award, and I have observed few things which are common across almost all the awards. So that will cover altogether at the end. So I'm assuming that all the presentations are over now. So I'm now giving the final comments on all the presentations. I assume that in the initial two groups presentation, since there was a lesser time, they were directly jumping onto the claimant's presentation and then the respondent's presentation. But when I told that time is not the constraint, the latter three groups presented it in a way in which it should be presented. So it was very good. Group number D and G presented it very well. G had some technical issues. That is perfectly fine. That does happen in practice, and that is the both the sides shown as to how it should be happen. Of course, it is a mock arbitration, so you continued with it, but practically, I told you what should happen if such kind of things happen. Okay. One more thing is that submissions and rebuttals. Yeah, in group number E, it had also happened. I guess that the E or no, it was in group number D. So the claimant and respondent kept on asking questions to each other and responding to each other. So practically, how it should happen is that the arbitrator will ask both the parties to submit their sides. Claimant will submit, then the respondent will submit, and then there may be rebuttals. In rebuttals also, claimant will have the rebuttals first, all the rebuttals at a time, and then the respondent may finish with all the rebuttals at a stretch, and then in respond to that, if further rebuttals are required, the parties may have that with the permission of an arbitrator. Because in some cases, particularly in case of emergency arbitration, it may be a documents arbitration. So in that case, the parties don't present anything. In that case, the parties only submit the document, and on basis of documents only, the arbitrator will pass an award. Okay, so you need to be very careful while submitting the documents in writing, and you should be covering all the points in that. So submissions rebuttals at a stretch need not be one point after another. Whatever a group G did can be the weakness, or it can be the way in which the group D or group E did. Like for example, when claimant is presenting, they may address all the issues at a stretch, or it may also happen like group G that they will go one by one. So first issue is addressed by claimant, then respondent, then again second issue claimant, respondent. So it is up to the arbitrator, because in this way, the way in which G did, it is better understood and better addressed. All the issues are better addressed. Okay, so it is up to arbitrator as to whether to go with one issue after another, because practically how it happens is that there are several meetings in which arbitration happens. It doesn't happen in one meeting itself. So it is better to address one issue after another. So let first party present on first issue, then the second party. Then once the first issue is addressed, then they may proceed with the second issue. And then once all the issues are done, then the rebuttals may happen. Okay. And again, it's not a code, so it shouldn't be a question answer format. So it should be one party presenting at a stretch whatever they want to present, whether it is rebuttal or it is the submissions. In case of facts, yes, I observed one thing that you have again presented a facts from your side. So to all the respondents, this is a message that if the claimant has presented the facts and you have nothing to add more to that, then you may say that the facts presented by the claimant are agreed by the respondent. We don't have any additions or clarifications into it.
Sure.
If not, if you have any additions or clarifications, then you should stick to those additions or clarifications only. Otherwise, it will be a wastage of time that you are again reiterating all the facts. Okay. If the claimant has presented the facts, you feel that any point is missed, then you can only cover that particular point which has been missed. Otherwise, not required to state the facts again.
Noted, sir.
Yeah. One more thing is, yeah, when you end the submissions, whether it is claimant or respondent, always say that these are my submissions on behalf of claimant or on behalf of respondent, whatever it may be, and then thank you. This I have already told you that start with the gratitude and end with the gratitude. Then to address issue one, I would like to submit. So when you are addressing, because in case of G that was not a problem, but in case of D, E, and the previous two groups, it was not exactly clear, or it may happen that the arbitrator may not understand which issue exactly you are addressing. Particularly when you go at a stage, you address all the issues at a stage in a single go. So always explain as to which issue you are talking about. The claimant, to address the issue number 2, the claimant would like to submit this. To address the issue number 3, the respondent would like to submit this. So do this so that the parties will come to know as to which issue exactly you are talking about. Reliance on law and precedent again goes the same suggestion for team G also. Um, so these are the submissions from my side regarding observations from my side regarding the presentation. As I told you, practically the stages of arbitration are like, first of all, arbitration agreement, then the notice of dispute, that response to the notice of dispute, then the appointment of an arbitral tribunal. Then after that, after appointment of arbitral tribunal, there shall be an initial conference about explaining about how exactly the arbitration proceedings will be carried out. In that again, as the group number D, E, G did, there shall be conveyed about the principles of natural justice, about the neutrality, about the language that will be used, because this one was the international commercial arbitration. So it may happen that the parties may not be aware about a particular language that has been chosen for the arbitration. So in that case, the arbitrator will have to communicate to the parties that if you are not conversant with the English, you can submit it in other language also, provided that you submit the translated version along with your submissions in English, because English has been chosen as a formal language for the arbitration. So all these formalities need to be conveyed in the initial meeting, and then after that, the actual proceedings will commence, wherein the claimant will file statement of claim. Then the statement of defense will be filed along with all the evidences. Any clarifications are required, that may be submitted in the form of supplements with the due permission of the arbitrator. Thereafter, the hearing happens. In hearing again, the witnesses, all the list of witnesses must be communicated in the statement of claim or defense itself. Then the witnesses should appear. It shouldn't take the other party by surprise. You shouldn't take the other party by surprise by bringing any witness at the last moment. It should be priorly communicated to the other party and to the arbitrator that these are the witnesses who will be present in the next meeting, and then the witnesses may be examined. After hearing, as I told you already, that if required, the expert investigation may be conducted. Expert may present their report. That report may again be, if arbitrator deems fit, the parties may be allowed to cross question or to ask the clarification from the expert. Otherwise, not required. Expert's decision or report will be considered final, and in that case, the arbitrator may not rely on the expert's report. Then thereafter, the arbitrator will proceed with the drafting of an award. And once the award is drafted, the copy of the award will be delivered to both the parties. And once that is done, the parties may have the chance of referring back the award to the arbitrator for any clarifications or any errors. And then the award may be enforced or it may be challenged. So this is how the arbitral proceedings happens. So which I guess you people have already learned about in the previous sessions. Now let me share the award which I have drafted, so that will give you a better idea as to how exactly the award is presented or should be. Okay, so let me share the entire screen. I hope the award is visible to everyone. Can anyone confirm?
Yes, sir, it
Yes,
is
sir.
visible.
So most of the parties have covered this. Both the parties name, who is claimant, who is not. The seat is covered. Governing law
Yes, sir.
is covered.
Yes, sir.
Language is also covered by both many of the awards. So that is very good. Introductory part basically talks about the facts of the case. Okay. So how exactly the parties are addressed in the award, that should be mentioned somewhere at the initial part itself, that henceforth the parties are referred to as global take, or you may also say that henceforth the parties are referred to as claimant, whatever it may be. So the arbitrator should clarify that. Then the facts, after understanding the facts from both the sides, the common parts should be called out in the facts. Then next is constitution of the tribunal. So the composition of the tribunal, by what law the tribunal was constituted, since it was the ICC arbitration in this case. So the particular provision of ICC rules should be cited. Very important that you cite the actual provisions of the applicable law. In this current proceedings, there were two laws applicable. One was procedural law, was that of ICC, and the substantive law was that of an Indian law. So those particular provisions of law, relevant provisions of law, must be cited in the award. Okay, then the procedural history as to what has happened, transpired before arbitration. There is something in arbitration called as cooling off period. So when I told you about this process of arbitration, when the parties give a notice to each other, after that notice a cooling off period starts. So what is cooling off period? Arbitrator may ask the parties that if required, you may consider the option of conciliation or negotiation. Have a thought about it. If not, then we'll proceed with the arbitration. So, in case the parties feel that there is a chance of conciliation mediation, that should be offered. That choice should be offered by the arbitrator to the parties. That is called as cooling off. And in case that fails, then the arbitration proceedings may commence. So, between the first meeting and the actual commencement of proceedings, the arbitrator may give a cooling off period to the parties. So, that was one point that I had forgot to mention. So procedural history, in case the cooling off has been offered and it could not yield any results, then that should be mentioned in this procedural history itself. Okay. Then the award should talk about the factual backgrounds again in detail. So here it was very brief introduction. It was basically the introduction to the parties as well as the brief introduction of the dispute very briefly, and then where exactly the seat will be, what will be the law governing the arbitral award, everything shall be stated, and then the facts in detail should be presented over here, followed by the issues. All the parties have covered all four issues very well in the award. Now here came the difference, wherein my award and the other awards were not matching, I guess. That is mentioning the Indian law, because that is the governing law. Okay, and it is very important that the award should cover the submissions of both the parties. What exactly claimant stated, what exactly respondent stated. Because as I told you, it may happen that if the respondent has lost the case or the claimant has lost the case, and then they may be under impression that their side has not been well heard of. So if you are covering their arguments in your award itself, then they cannot state that their arguments were not heard, because you can then say that because the award itself covers their arguments. So it is very important that the arguments of both the parties, submissions of both the parties, are well covered in your arbitration award. It is for that reason the written statements are collected. So you should, even after hearing the parties in the meeting, you should again go through the written submissions and then check out what were their submissions. Okay, issue by issue the arguments may be covered. Then tribunal's analysis, very important. Many of you have, after covering the arguments or after covering issues, have directly jumped onto the decision of an arbitrator. So that shouldn't be a case. Your own analysis, parties have presented their arguments, but what is your understanding, arbitrator's understanding about the arguments? Which one was true, which one was not, what exactly the law excuse me, what exactly was the law, does the law has to say about it. Group D did talk about few precedents which I mentioned in my comments also, but I couldn't see those judicial decisions or precedents in the award. So arbitrator should in detail talk about that particular precedent which the parties have raised and which the arbitrator feels that the it should be relied upon. So be very clear with respect to the law, the precedents that you are relying on while making your observations or while passing your analysis. Then breach of SPA was the core issue of this entire dispute, and hence you should very clearly tell as to whether there was a breach or not. If yes, why there was a breach, what exactly amounted to breach. Okay, like for example, innovative corps failure to disclose. This is the reason that I'm giving. The arbitrator is giving. Okay, so because of this, I believe that there is a breach of warranty. Okay, so the reason should be there. Then the remedies. So now you have come to conclusion that there was a breach of contract. So now what is the remedy that you are giving? So again, that should be divided into the points, because there were certain remedies which were claimed. One was regarding the indemnification. So for indemnification, there shall be a separate clause. The second remedy that was claimed was a rescission of contract. So whether rescission should be permitted, what exactly is the Indian law? Does the Indian law say about the rescission? On what ground rescission is permitted? Whether there was a misrepresentation or it was a case of fraud. Okay. Then again, the judicial precedents are relied upon. That should be clearly mentioned. That relying upon this particular judicial precedent or the arbitral precedent, we are saying this. Because why I'm saying the arbitral precedents is because ICC does publish their awards. I hope you are aware of it. So in case of arbitration also there may be a published award and precedents already available, so you should be mentioning those case numbers of the particular award. Then very important that you should clearly state the amount of compensation the other party should pay. So which if you say see, I guess I have mentioned that somewhere in the award. Yeah. So in the actual part of decision, yeah. So here I have mentioned it USDX. So whatever the amount of compensation that you want to afford to the party, winning party, you must clearly define the amount. That is, let us say, $10,000 million or $10,000 US dollars. It should be clearly defined. All the awards I have gone through, they just say that the respondent should indemnify the claimant, but you cannot say that indemnify, or you cannot use the word reasonable indemnification. You should be very clear, because that would lead to unclear or unclear award, and then the parties will again approach back the arbitral tribunal. So your decision clause should be very clear as to what exactly is your decision, should be very concise. I have seen that in few awards they have written almost a para in this decision part. No, it should be in a statement. Regarding breach, what exactly you have to say. Regarding rescission, what exactly you have to say, whether you are allowing it or dismissing it. The reasons have already been covered in the analysis part. Okay, so decision very clear in single sentence. Each and every point should be covered. Interest, if at all any, is to be conferred. I could not see this point in many arbitral awards, so this should be considered. Almost all the arbitral awards does impose interest rate, so in that case, what exactly is the interest rate, that should be clarified in the award itself. Usually the practice is that an interest rate between 12 to 18% is charged. So arbitral tribunal should specify as to what percentage is exactly charged for, and then the cost, why exactly that percentage is identified. I could see that one of the award has exactly similar clause in their arbitral award. So very good, 70%, 30%. It should be clearly defined how much shall be the cost borne by each party. And very important is that you should declare the award is final, which almost all the awards did mention, but the point that you missed on is the law, under which law exactly it will be considered as binding. That should be mentioned. So very important element is that you should mention the legal provisions. The award should be divided into several parts. First of all, the introduction, then um, the constitution of tribunal, then followed by that the facts of the case, followed by the issues, followed by the arguments by both the parties, submissions by both the parties, then followed by the tribunal's analysis, then followed by the remedies, then followed by the decision. The decision should be very concise. Legal provisions, the precedents must be mentioned, and then the finality of an arbitral award under any particular law that you are relying on, and then signatures, which I guess all the parties, all the awards have already covered off. So this is how the arbitral award should be. Any doubts?
Yes, students, any doubt you can ask from the sir.
So very important point is that you are addressing each and every point raised by the parties. So for that purpose, you must mention the respondents' arguments, claimants' arguments, and then in your tribunal's analysis part, you are addressing to each of those concerns. Particularly, as I told you earlier, the losing parties' arguments must be addressed point by point. Okay, so that they will not have any misconceptions in their mind at the end of the award. Okay. In some cases, it might happen that the parties may waive off their right to challenge the award in the arbitration agreement itself. In that case, the award should also clarify that the parties will have no right to challenge, as they have waived off their right under so and so clause of arbitration agreement. To save the time, such kind of agreements may also be there. The right to waive off the arbitral challenge. So, in case there are no doubts, I guess we are done then. Rohit sir, any further clarification required from my side? I hope I have done the justice with the job.
No, sir, I don't think so. I think so. It's pretty enough. Means you have explained the concepts very well. Yes, students, if any students are having any doubt, you can please unmute yourself and ask questions to sir.
Sir,
Yes, sir.
is it necessary to evaluate the brief evidence in the award?
Evidences may be mentioned in the award, but you need not attach a copy of evidence. So you may say that relying on the statement of witness number one, arbitral tribunal holds the opinion that so and so. Okay, so you are expected, rather the arbitral tribunal is expected to mention the evidences cited by the parties, whether they are admissible or not, if admissible, why they are admissible, if reliable, why they are reliable, why they are being relied upon by the arbitrator. So that should be mentioned in that.
Okay. Thank you, sir.
Yeah.
Any more questions, students? I don't think so. There are any questions. So can you stop sharing your screen?
Yes.
Yeah. So I think so. One student has a question in chat box.
Yes, sir.
Can party councils bring in evidence in person like regular courts?
Yes, witnesses can definitely be brought forth. As I told you, you should give an advance notice. In your submission only, you should mention as to who are the witnesses that will be appearing in the arbitral proceedings. If I'm filing the written statement, then that written statement should be supplemented with the annexures. In the annexure, I should clearly mention who will be the witness, why the witness is relevant in the case, and then the arbitral tribunal may fix up the schedule accordingly as to when exactly the witness is supposed to be called for, and then that witness may be relied upon, as I have just now said while answering Mr. Raju's query, that the witnesses evidence is submitted may be mentioned in the award. So yes, like court, the physical witnesses may be brought before the arbitral tribunal, maybe virtually or maybe physically. Always better to bring them virtually so that they don't have to travel upon for that purpose. Because in case of international arbitration, that will be very burdensome. Most of the arbitrations nowadays happen online only. So online, you can make an arrangement for their participation.
Okay. Thank you, sir. I think so. The session was quite brainstorming. The practical aspects that you have given the glimpse, the you have discussed the arbitral award also. So I think so. The students are really benefited with the sessions, and the students have actively participated, and you have steered the sessions. So I think so. This practical aspects and this practical approach will surely help our students.
Yes. Thank you so much for calling me, for giving me the opportunity to observe such a intelligent bunch of students, and they have rigorously presented their case, their arbitral proceedings. So they shouldn't stop here. They should continue this practice. Keep organizing various competitions, ADR competitions, so that they will benefit out of it. And they should also consider doing some internships with the arbitral firms in Pune. There are quite a few arbitral firms, advocates who are practicing in the arbitration, and keep arranging the guest lectures so that they will keep abreast themselves with the recent developments. To the students, I will say that please keep on referring the website of SISC, because Singapore International Arbitration Center is the very advanced arbitral institution. Even the Western arbitral institutions like LCIA follow them. There are some practices which even the Western arbitral institutions are not following. So they are very much advanced as far as other arbitral institutions are concerned. So do follow their rules, their procedures. They will be highly helpful for all of you. And also keep visiting the Walter Kluwer's blog, because they keep on updating about the recent arbitral developments.
Awesome.
Thank you, sir. Am I audible, sir?
Yes, sir.
Yes, sir.
So I think everyone please switch on your camera for the snapshot, so you can keep it a record. Ans, if you are there, you just take the screenshot. Is it done? Ans? Oh yes, he has messaged me.
Yeah.
Yes, yes, yes.
Yeah.
It's done. It's done. Thank you. So, shall we start with our valedictory session, sir?
Yes, sir. Surely.
So, with the deep gratitude and a heartfelt of joy, I stand before you at the valedictory section of our 7 day arbitration and conciliation course. I start with the slok Vidya Vivadai Dhanam Madai Shakti Paresha Parpidnai Khalasya Sadhu Parit Metat Jnanaय Danay Cha Rakshanay. Meaning, for the wicked, knowledge breeds argument, wealth breeds pride, and power brings oppression. But for the noble, knowledge is for wisdom, wealth is for charity, and power is for protection. It is my honor to show my gratitude to our Dean and Principal Dr. Uzvala Bendale ma'am, Vice Principal Dr. Jyoti Dharm ma'am, and IQAC Coordinator Dr. Vidya Dede ma'am, and honorable guest speaker Dr. Vikrant Yadav, assistant professor at MIT University, and my fellow organizing members and dear participants. And also, and most importantly, to my colleague Dr. Rohit Survasi sir. Actually, Vikrant sir, our idea germinated with the concept of mock arbitration and how to draft arbitral award and clauses. So we decided to go on to the practical approach towards the arbitration. So we divided the course into the 7 days naming. The first day was Prastavna, where we discussed the basic understanding of arbitration. The second day we discussed the Dwarpal, in which we discussed the arbitral clause, how to draft the arbitral clause. Third day, the session was named as Nirnayak, where we discussed the arbitration agreement and the jurisdictional challenges. The fourth day, that was the Vijay Path, we discussed the roadmap of arbitration proceeding, in which we tried to discuss how to choose the arbitrator and the case management strategies. The fifth day was Vad Vivad, where we started focusing on the advocacy techniques in the arbitration argument and the professionalism and ethics in arbitration. The sixth day was based on Falas Siddhi, in which we tried to discuss the airtight, how to draft airtight arbitral award. And the seventh day, that is today, that is Pariche, we wanted to discuss on the hands-on experience on the mock arbitration. So we decided this and we drafted the course on the basis of 7 day course, namely all such name I have just mentioned it. And we have also sent a draft for copyright and it will come soon as we are hoping for it. So the past week has been a journey of discovery and discipline of learning what, the how, and finally the why of arbitration. From understanding the foundation of dispute resolution to exploring enforcement and remedies to finally stepping into the arbitrator's shoes. Today, we have not only gained knowledge but also experienced the spirit of justice beyond court. We are equally grateful to our guests, expert, and faculty members who illuminated our session with their insights and made us realize that arbitration is not merely a process but a philosophy of resolution, neutrality, and fairness. Over to you, Rohit sir.
Thank you, Shubham sir. न्यायात्मा बलहीने लभ्यम न च प्रसायत तपोस अवाप्य. Truth and wisdom are not attained by weak or careless, but by those with strength, discipline, and perseverance. Here we come to the completion of our skill and capacity building program, Saamanjasya. Let us carry forward not only the techniques and skills of arbitration, but also spirit of fairness, balance, and justice. May this feeling shape us into lawyers, arbitrators, and citizens who resolve conflict and wisdom and integrity. A special thanks to all the participants who have enthusiastically, curiously participated in throughout the sessions and throughout the mock arbitration session. On behalf of the organizing team, I once again thank you each one of you for being a part of this journey. With a formal declaration of the conclusion of the course, I conclude the course with the words Anta Asti Prarambha, means Anthi ek nayi shuruaat hai. So, with this conclusion of the course, Each participant will step out with a skillful, capable, and a competent counselor and arbitrator. Once again, on behalf of all the organizing team, I thank all the participants and special thanks to our working committee Ansh and Priyanshi for steering the sessions throughout the 7 days. Thank you, sir. Thank you, all the participants, and thank you, Vikrant, sir, once again.
Thank you so much for the opportunity.
Thank you, Vikrant. Yes.
Thank you, sir.